First, it must be shown that the claim of one party is positively opposed by the other. Second, the date for determining the existence of the dispute is the date of the application, but subsequent conduct may be considered. 3, whether the dispute exists must be determined by an objective determination of the facts. And 4, a dispute exists when it is demonstrated on the basis of the evidence that the respondent was aware or could not have been unaware that its views were positively opposed. When these propositions are applied to the facts of this case, it is incontrovertible that a dispute exists between South Africa and Israel. South Africa strongly believes that what Israel is doing in Gaza amounts to genocide. Israel denies this and claims that such an accusation is legally and factually wrong and, moreover, is obscene. So an objective determination of the facts shows that a dispute existed on the date of the submission of South Africa's application, and this has been confirmed by Israel's subsequent statements and by its continuing conduct in Gaza. Moreover, Israel must have been aware from South Africa's public statements, the démarche, and the referral of the matter to the International Criminal Court of Israel's genocidal acts that a dispute existed between the two states. Madam President, the court has indicated that in an application for provisional measures, it is sufficient to show that there is a prima facie basis for jurisdiction. It is submitted that South Africa has convincingly established the existence of a dispute between it and Israel over the fulfillment of the latter's obligations under the Genocide Convention. Finally, it is submitted that regard should be had to the special considerations that apply to the existence of a dispute under Article 9 of the Genocide Convention between a state that brings an application in furtherance of its obligation to prevent genocide and a state accused of committing genocide. This concludes my speech, Madam President. I thank you, the members of the court, for your attention. I now ask you to call to the podium Professor Max du Plessis to address you on the nature of the rights requiring protection and the link between such rights and the measures requested. Thank you.
I thank you, Professor Dugard. Before I give the floor to the next speaker, the court will observe a coffee break of 10 minutes. Sitting is adjourned.